Hi, everybody. Welcome to the Long Beach Community Foundation's webinar on estate planning basics and how to avoid probate. We are so glad that you've joined us on this foggy, almost fall Friday to talk about a subject matter that is very, very important and maybe not the most popular topic, but my colleague Jenny and I are just delighted that you joined us today for this very important discussion. What we're going to talk about today as we get through it is going to be about 45 minutes. We'll probably take about 30 to get through the material and then really open it up for questions. And just keep in mind, if you would, universal questions are always the best rather than anything starting with my, me, or mine. And because those questions can be answered maybe privately with Jenny or another estate planning attorney. I would like to let everybody know that we are recording this webinar, and you will receive a copy of this if you've registered, and you'll get a copy so you can review it and share it at another time. And we will take questions at the end, but feel free to go into the chat and type your questions in there. I'll see them as they come up, and then we'll pose those to Jenny or myself at the end. And so, okay, well, let's just jump into it. The specific things that we're going to talk about today, if you don't know about the Community Foundation, we'll fill you in on what we do. Jenny's going to go over some estate planning documents, how to avoid probate, how to include charity in your trust from yours truly, and then really share some free tools and resources for you to continue the conversation after today. We want to start with a poll because we'd like to know who you are, who's joining us, and maybe some of our conversations can be tailored to what the best needs are of the audience. So maybe you're here because you need to set up a trust. Maybe you're updating a trust that you have, you need to dust it off. Maybe you're interested in including charitable giving into your existing trust or a trust that you're planning to put together. Or perhaps you're a professional advisor, maybe a financial advisor, another trust attorney, maybe a CPA. You might have clients that are interested in how to incorporate charity into the trust. And those are all really great reasons to be joining us today. And it looks like kind of a third, and a third. Well, that doesn't make any sense. A fourth, and a fourth. If you're interested, some of you, about 30% are interested in setting up a trust. Another 30% are updating your trust. And about 20% are interested in adding charitable giving to your trust. And another 20% are you're a professional advisor. So welcome again. Okay. So we'll close that poll and move on to our first slide. So the Community Foundation's mission, of course, is to initiate positive change for Long Beach through charitable giving, stewardship, and strategic grant making. We are 25 years old this year. If it's not obvious from the big logo, we had a big celebration here this year through a series of webinars and other celebrations. And we're one of over 850 community foundations across the US. Really what we do is we are the administrators to different types of funds that connect and really support charitable giving, either with professional advisors directly or with you directly as an individual. Many people know that we work a lot in Long Beach, but we like to remind folks that we do have national reach. And we're a hub here in Long Beach. We have 5 staff, but we have 100 in Greater Kansas City that expands our charitable giving portfolio and a lot of the resources that we provide as well. So we're local and nimble and strong and national as well. Here's a list of folks that we work with, really the professionals in the industry. We also work with charities directly and corporations. We work with individuals, and you might find yourself, if you're updating your trust, as one of these type of groups that we work with. All very beneficial for making sure your trust is put together and including charity. It is my distinct honor and privilege to introduce Jenny Sawday, a local state planning attorney for TLD. And the reason why we love partnering with Jenny is because, quite frankly, she is the real deal. She has been through this personally, she'll tell you. And the ability to avoid probate is so important, and she really cares about her clients. She truly cares about avoiding, the pitfalls that can come up, and she's been doing this for a lot of years for a lot of different clients and situations. So without further ado, I do want to hand it over to Jenny to start the presentation.
Okay, thank you for having me, and thank you, Marcelle. Happy Friday. Those of you that are here that are in the professional capacity, I want you to write down and understand that this will help you teach others about estate planning from the attorney's perspective. Those of you that are here to talk about your own trust or setting up a trust, I want you to take a paper that you have in front of you and your pen, and I want you to write down right now 4 words. And we're going to go over them in the presentation, and the aha will come later. I want you to write down the word trust. I want you to write down will, and then I want you to write down power of attorney, and then I want you to write down medical directive. So if you have a piece of paper in front of you or on your phone, take notes. Write down trust, will, power of attorney, medical directive. And then this presentation will focus on what all of those things are and how those 4 documents make up an estate plan. So the first one, and this is a great chart, it talks about what is a living trust. It's something, if you look at all the little graphics, it says it's something that's established during your lifetime. You are the creator. You are the settlor. You are the trustor. That person is the person who creates the trust. You put it into being. It's like a fishbowl or a funnel. It's something that's there and you have it. And you put stuff in it. You put your home, so the property goes in it. Your bank account, your life insurance, your home, rental property, you put stuff in it. While you were alive and well, you are the creator, and you are also the person who manages it. And as the manager, you are considered the trustee. When everything is in the trust and is funded properly and you pass on, you hand over that fishbowl or that funnel or that stuff to your successor trustee, and they read your instructions, they distribute, and then they end what you have with your estate without having to go to court. So the trust during your lifetime is always revocable and amendable during your lifetime, so that's important. So when I talk to clients about setting up a trust, or people call me, Jen, I need to set up a trust, or I get that email, help, I need a trust. What you really need and what you probably mean is setting up an estate plan. And it goes back to those 4 words that I wanted you to jot down. I want you to write your own note for how you understand what these terms mean, because these are important for you to tell others to make sure you have it. If you have a trust and you have a book, after this webinar, go home, or if you're home, open your book, take your tags, your stickies, and say, wait a minute, do I have my trust? Do I have a will, power of attorney, healthcare directive, and read it so you know. If you only have a few things and something's missing, and that has happened, if you did something in the 80s, 90s, and early 2000s, maybe you just did 1 document and not all 4. I want my clients to have all 4. So let's go back to what the documents are. So we have trust, pour over will, durable power of attorney, and then the medical directive, which is called in California, advanced healthcare directive. When we set up the trust, we also want to put a list called a Schedule A or a Schedule of Assets that tells your successor trustees what you have that is in the trust. People put things in, and if you pass and they open up the book, I want them to be able to look on your pad, on your schedule, and say, oh, I've got stock at Home Depot. I've got an account along the school credit union. Oh yeah, there's a small account at Navy Federal, or there's an online account at Capital One. If you put it on your schedule, then you're telling everyone an index of what you have and where to go. So these are the 4 documents that we talk about making up an estate plan. Okay. So let's go to the next chart. So here, when we talk about a trust, you get to decide who's in charge and where does it go. When you put everything in a trust, or everything has beneficiaries or is connected, then it avoids probate. So if you own a home in California, anything, a condo, a small co-op, a single family home, an apartment building, a commercial building, any property in California will be subject to probate unless it's worth less than $166,000. So let me tell you, there's probably not a house in the state of California less than that amount right now. So my rule of thumb is for any homeowner, property owner, the minute you're entitled to property, you need to set up a trust to avoid probate. Now you may say to me, my wife and I own it, or I own the home with another person and we're joint. Does that avoid probate? Yes, only on the death of the first joint tenant. on the death of the second joint tenant, that property will wind up in probate. So I advise all property owners to set up a trust to avoid probate. So if you have a trust already and you have property and the property tax bills just came, pull up your property tax bill and look up on the top and just say your name, Jennifer Sawday, comma, TR or trust. If it says it on your bill, then you have assurance and confirmation that your home is actually in the trust. So that's a good thing to check up on. So when I set up a trust for someone, the next document that I set up is called a pour over will. That's document number 2. When people set up a trust, we need to set up a will as a backup. It's called a pour over. So you've inherited money, you're buying another property, you're on your way to Palm Springs, or something's coming in, and you die before you put that property in the trust. So let's say you're buying that vacation home in Palm Springs, and you pass away just after escrow closes, but before you had a chance to put it in the trust. The pour over will takes it and pours it back in the trust as a backup. So most of my clients and most of you that have an estate plan already set up, if everything is in the trust or has the beneficiary, the pour over will is not used. We take it, we put it aside, we don't need it. But sometimes someone's in the middle of a transaction. You've inherited money, you won the lottery, you're buying another property, something more is coming in. The pour over will is a backup. Said, hey, Jennifer died, there's something that we forgot. Let's put it back in the trust. It will go through probate, but it makes it easier. I don't want to use it, but it's there just in case, okay? So that's what the trust and the will are about. The next two, power of attorney, and then the next chart called the Advanced Healthcare Directive, are important documents for anyone the minute they're 18. If you're 18 and older and something bad has happened to you, you got hit by a truck, you're flat on your back, who's going to come into the hospital, grab your phone, grab your purse, manage your house, take care of your cat, make your car payment? You're alive, but not well, but you're going to get better. You need a durable power of attorney. The word durable means it lasts even if you are incapacitated. Most powers of attorney spring. They come into action if you are considered incapacitated, meaning 2 medical doctors sign off to say, you've lost mental capacity. If you regain capacity, then it goes back to not being divorced. It's a good document to have just in case. Along with the power of attorney, we recommend that you set up a medical directive. Something bad happens, you're in the hospital, somebody needs to make a decision for you. You are badly injured, you're in surgery, you're aging, you're not well. Who's going to make those medical decisions? You get to put that down in a medical directive. So I have a 17-year-old daughter. She's going to be 18 next July. The minute she's 18, first thing mom's going to make her do is sign what? A power of attorney and a medical directive. And she may not name me, I think she will, but she may not. So those are important documents that when I set up an estate plan for the family, I do all those 4 documents. And if I have kids that are just over the age of majority, 18, 19, 20, I will usually do the power of attorney and the healthcare directive for the family at no charge. Because I don't want the parents to be all planned up and buttoned up. And all of a sudden something bad happens to the kids, especially if you go away to college. I still want the parents to be able to help. But when I have the meeting for the kids, I always say, you don't have to name the mom. And they always say, no, put my mom first, and my dad second, and then put my older brother third. So it was a nice thing to do for the family. So here we've got a poll. Marcelle, do you want to do the poll?
Yeah, so we're just curious, and Jenny, this is your question in terms of serving as the trustee or executor before, and there might be some people on here that have not put a trust together and may not even know what the term trustee or executive are. Can you just for like 30 seconds describe what those are?
Okay, so the trustee is the person who is activating or managing what's in the trust. The executor means we've had to gone to court and we've activated the will. So if someone's acting as a trustee, that means we're following the rules of the trust. If someone is acting as the executor or the administrator, that means we have a will and we're in court. There's a catch-all term for both. When someone passes away, it's called a personal representative. Who is your personal representative for taking care of your estate and winding everything up? If they're using the trust, they're called a trustee. And if they're using the will, they're called the executor. Wow, I love this poll.
Yeah, it's interesting.
So
So about 25% of the folks joining us today say that they have served, and better planning would have made for a better experience, but 75% said no. So they've avoided that, and thank goodness. That's interesting feedback. Thank you for saying that. We'll go ahead and close that and go to the next slide.
Okay, so I drew up this chart in one of the marketing meetings back in 2019, when we were meeting in person. And it's one of those things where you go around the room and everyone talks about why you should hire me. And everyone's saying that, the CPA says it, the financial planner says it, the insurance person says it, and then it was my turn. When you're alive and well and you come in and you see me or you see my competitors, all my competitors in Long Beach are terrific. You can't go wrong with any of us. The fees are the same. It's normal. No one's unhappy. You're prepared. Life's good. It's easy. You pay the minimum and that's it. But if you're seriously ill, I'm not a doctor. I didn't go to medical school. I went to lawyer school, right? I went to law school. I do not like the sight of blood or the sight of vomit. So when you call me and you say, oh, can you come to the hospital? I'm like, I don't know about this. And then my notaries don't like it. We're not in the medical profession. We didn't sign up for this. So when we have to go, we're uncomfortable. You're uncomfortable. And then we have to charge a rush fee because usually you call me on a Friday, and I hope I don't have this today. Somebody's gonna die. We need to do it by Monday morning. And then all of a sudden you're paying, 2 to 3 times as much, but everybody's uncomfortable. And then if you have passed away, there's nothing we can do. We have to go through probate. I have no tools in my toolbox. If you own a home and you have died and you're the only person entitled, that's the probate. And you just get to pick the probate attorney you want to work with, and the fees are standard. Each attorney gets paid exactly the same amount in probate, so there's no untoward competition that way. But here, this is a good chart. I know it's hard to read. The whole point of this chart is literally just to make you angry. Wow, this probate stuff's expensive. So if you look, probate has fees and it has costs. The cost of probate, just to open the petition, just to file it, is $465. To close it, when I'm ready to close in about a year and a half, is another $465. $465 is a pretty good trip to Costco. That's a lot of money. So if somebody passes away, we're writing checks. I'm not writing checks, you are. So by doing the estate plan, we're avoiding all this. And then we have to do all of these other costs. Most probates have a cost of about $3,000 to $3,500. They have an emotional cost, they have a time cost, it takes about 2 years now. And then the fees. The fees, the formula is the commission. So at the end of the probate, if the house is worth $500,000, the attorneys get a fee base of $13,000 for doing the work. And the reason why they get the fee is because you didn't set up a trust. There's just nothing else to it. You come to me and you say, I had this last Friday, actually. Somebody called me and said, Christopher died, and his name was Craig, and they had the same last name. And so I didn't know who Christopher was. So my first question to this man was, so who was Chris? And I was expecting him to say his father or his brother. And it turned out to be his son. I about cried on the phone. And what was even worse, that his son was the same age as me. And I was like, wow, I'm really sorry. And he said, yeah, I'm from Arizona. I'm coming out the following Friday for my son's funeral. I want to hire you to do the probate, and I want all the forms ready. And I had nothing to say to this man, but yes, of course. The minute you get here, so he says to me, Friday, I'm going to be driving from Phoenix. I'm going to leave at 4 a.m. The funeral is at 2. I'm going to be in your office at 11:30. I said, yes, sir. You be here, I'll have it ready. And he came. I moved some appointments around, and we got everything done. We're opening probate. About 90 days to get it open, over about 2 years to close it. It was one of the saddest things I had ever had to do, this past year, other than the COVID death, to have him, have his son passed away like that. And it was not from COVID. So let's talk about this chart. This is a good chart to keep in mind. This is also something to watch. Estate planning is also estate tax avoidance. We do have a lot of clients that have a higher net worth. And we have ordinary clients that have ordinary net worth. And keep an eye on this. The number from Trump when he was president, the estate tax exemption net was high. It was 11 million a person. It's a little bit higher than that now. It's 11.8. It gone up just a little bit for inflation for 2021. If you pass away and you have less than 11 million in the bank, value of the IVA, property values and all of that, if you die this year, there's no estate tax, so that's good. California doesn't have an estate tax at all. That could change, so keep an eye on that. But look at this. Federal estate tax is set to come back. It's supposed to sunset to the Obama numbers. So if be adjusted for inflation, we think it'll come down to about 6 million if you pass away in 2026. At 6 million, quite a few of us could have what we call a taxable estate. 6 million can be 100,000, from retirement account, 1 million in a life insurance policy, the value of your home. Maybe you've inherited a property, and all of a sudden you find yourself having a higher net worth. You may have a high net worth and not enough cash, but keep an eye out. This is also part of the tax packages that are going through Congress now. We don't know what the exemption amount will come down to. You have to keep an eye on it. Some of the work that I do for estate planning is estate tax planning to avoid or to minimize.
Jenny, I think you're frozen there. So when you come back online, we'll invite you back. Just let us know. It's really interesting because I learned something new every time Jenny presents, and we have the opportunity to engage her. When she was talking about probate, a lot of our presentations are how to avoid probate, like have those conversations. And that's why the Community Foundation puts this on for the community in advance, kind of in advance of the holidays, so that when you are around the table, you can have those conversations and start that up early, as uncomfortable as it can be. But to avoid probate, so you're not rushing at 4 in the morning and calling Jenny and she has to drop everything, or your estate planning attorney. It's just so much better. So I see you're back online, Jenny. Back to you.
I'm at the airport, so sometimes the plane comes over and then my connection is unstable with the Wi-Fi. Sorry. Yeah, so thank you, Marcelle. I'm glad you know me so well. You know what's coming next. You've done so many of these. Yeah, you want to make sure everything's in your trust. If you have the trust set up, having a trust is not enough. You've got to put stuff in it. So like my home is Long Beach. When you pull title, you look at my property tax bill, it says Donald and Jennifer Sawday, trustees of the Sawday Family Trust, dated June 14, 2004. You have to put it in there. So that's how you put things into the trust. But there's one other thing that I want to talk about is, I think it's on the next chart, is putting bank accounts into the trust. We go to the next one. Yeah, this one. So look, let's talk about, I want you to write down everything that you have. It should be on your schedule. If you don't have a schedule, I want you to make one. And I want you to put down homes, rental properties, timeshares, bank accounts, checking, savings, annuities, IRAs, brokerage. And then if you have digital accounts, you have money in Venmo, you have the store in SC, you have Bitcoin, you have cryptocurrency. I want you to list everything. And then I want you to write down if you have paper things. You have shares of stocks from Disney that you got as a kid. You have paper savings bonds. I want you to write, and then I want you to do a schedule. Everything in the Sawday Family Trust, whatever you name it. And I want you to write, I have this, 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 this. And then write down the 4 digits of the account number, the last 4, and put it all in there. Now, the whole goal of setting up the estate plan and doing all the documents is just in case something happens, right? You get hit by a truck, who's gonna help make financial, medical, right? We've got that. The trust has to work because everything has to be funded. To write down what you have. You have oil rights, mineral rights, anything, partnership, LLC, business, anything, you know. I don't know, Marcelle doesn't know, but you know. Write it down and then ask me or your attorney, whoever it is, how do I connect it? Now, bank accounts, that's your job. I don't want clients to have 200,000 or 10,000 sitting in a bank account and have that account have nowhere to go. If you call the bank, Navy Federal, what happens if I passed away? Where did that account go? And the bank will go, you tell me. Then you say, oh no, let's put that in my trust or let's name a beneficiary. This chart is something that I want you to focus on. I want all bank accounts to get connected somehow. You can make the trust the owner of the account. So if you have a bank account at F&M, US Bank, or whatever, and you open up the bank statement every month, I want it to say Sawday Trust, or whatever you name it, then you know it's in the trust. If the bank says it's too hard to put it in the trust, then you can make the trust the beneficiary. And then the next option is, if you don't want to connect the account to the trust, is that you can name individuals to be the beneficiary. So if you have a favorite niece and you want her to get this account, then you can make your niece the beneficiary. We want everything to have a place to go. So one of the other things that we talk about when we set up a trust is, and I asked all of my clients this, do we want to do it in charitable giving? So we've got a good poll on this to kind of see how interested you are. But I have clients that come to me, and I had one the other day, they say, I just want to give scholarships to local high school students in Long Beach, how do I do it? And I said, we call Marcelle.
We appreciate that. And as you're taking a look at this poll, you know, I just want to emphasize the fact that the Community Foundation does these webinars for the benefit of the community. So we're doing this just to let everybody know, you know, this really vital, important information that we happen to be experts on. And also we engage people like Jenny and other attorneys to, you know, share their time, which is very valuable, to educate the community on getting ready and planning and being informed and being part of that process. You are the owner of your trust. You are the trustee. You are in control, and you can say what happens the way you want it to happen. There is this other piece though, charitable giving. Where does that fit in? And maybe some of you think, you know, you're really interested. Maybe you're somewhat, because you're not quite sure where to give, or, you know, how to give, or what are the most important you know, charitable causes. And maybe you change your mind a lot. Maybe things happen in the world, situations change, and suddenly we're in a pandemic, and now I want to give money to, you know, provide food and shelter to people that have been laid off or something like that. But then in a few years, it might change to something else that really tugs at your heartstrings. So it looks like about 40% of you say you're very interested in charitable giving, and another 15 are somewhat. And then 46% say you're not sure, can you change your mind later? And the answer to that is absolutely. So I'm going to share with you some of the resources that we have, and kind of some of the ways that you can go about it. So first of all, there's several ways you could include charity in your trust, and I'll go over some of the bigger ones that people come to us to talk about. One of them, this first thing called a charitable remainder trust, or a CRT, typically we see with individuals and families that own a property, maybe a rental property, apartment building, or some kind of a large asset. And they really want to not deal with it anymore. They don't want to be property managers. They still would like a little bit of income from it, but they really just want to let go of the responsibility. And they're charitably inclined. So you might already be giving to your church. You might be already giving to a particular charity. You might have a fund at the community foundation that you're giving to. But all of those reasons are good in terms of receiving a major tax benefit. So avoiding a lot of that capital gains when you sell the property. And then you receive these annuity payments. So the process is you donate the property to the community foundation. We sell it. We put the money in a trust. And that trust produces income from being invested. You receive those quarterly annuity payments, which is based on an actuarial calculation of your age and all of that. And when you pass, whatever's left, or the remainder, goes to charity. And you coordinate all that with us to make sure it goes to the charity of your choice in the way that you intend. A charitable gift annuity works very similar to all that, but typically the gifts are a bit smaller, and sometimes they're mostly cash or appreciated stock or some other kind of asset other than real estate. Donor advised funds, they're the, go ahead, Jenny.
Yeah, most of my clients, when we do charitable gifts, we actually do the first option that she has on here.
The charitable remainder trust, yeah.
So
and then
we usually just put in the trust a gift to the Long Beach Community Foundation, and then we specify the amount as a percentage. Most clients that I see, and they're your property will do the charitable remainder trust. So I don't want you to be afraid of, if you want to give the foundation something or a charity something, as little as 10,000 is a welcome gift. When people pass on, and I have a successor trustee, that's the first check that they're happy to write. Oh, she loved so much this charity, or he was very passionate. And my trustees are always happy to write those checks. So it's something I see on the opposite. When people leave the planet, everyone is very delighted to make these gifts.
Yeah, it's important, and it might be described as if you don't have children, a lot of time you will have those assets, and you'll be ready to give to charity because they better to go to charity and charity causes. Or maybe you have relatives, or there's different options there. So we can sit down and talk to you about that and see what might be the best thing for you and your personal situation. Donor-advised funds are the fastest growing charitable vehicle in the United States. You can think of them like a charitable checking account. There's these other type of funds that help you where you're specifically choosing a focus, or you're choosing the charities, or maybe education and youth are important to you. You want to set up a scholarship fund that we administer. All of these accounts can be set up today, and you can activate them now. You can give through them. You can work with us to give in your name while you're here, so you can enjoy that relationship with those charities, either in person or anonymously. You can put your name on it, or you can put a generic name just to sort of be more in the background. But they're activated also upon death, because a portion of your estate then will go into these accounts and then bolster them up, and then we're giving in your name after you've gone. And of course, the funds increase exponentially after that, and then the money that we're putting out on your behalf gets even larger. So moving along here, the Community Impact Fund, this is something we've administered since we started 25 years ago, and every few years it changes. It's directed by our board, who are members of this community, care deeply about Long Beach, and really point those dollars and inject them right into where they are the most effective for Long Beach. And the homelessness has been really at the top of that list for the last 3 years. There's a document that all this documents. It's called a Memorandum of Philanthropic Intent, or MOPI as we call it. And here is where, here's the mechanics of how that works. So you work with your estate planning attorney, you write the Long Beach Community Foundation into your trust. And then on the side, we have a document that can be changed throughout your lifetime. It's something that you pen and sign and give with us, and we have it securely filed here at the Community Foundation. And you can change it at any time, and there's no cost for that. Individuals like it because, and estate planning attorneys like it because you name one charity and you don't have to ever amend that part of your trust. But outside of your trust and with this MOPI document, you can choose causes, you can pick charities, you can have your trust point to this document to outline, this is what I want. So it's a really great, easy tool, flexible tool that we highly recommend. So here's kind of what I just said in terms of how the mechanics go. I think the most valuable for the folks joining us and listening to this is to understand that we will be here after you've gone, and we will make sure that what you wanted to fund will get funded. Whatever charities you chose, whatever programs you chose, there is a board of directors, there are staff here, there are backups to backups to backups to keep your records safe and secure and executed. And we will make sure that those charities are fulfilling your intentions. And if they're not, we will catch it and we will redirect those funds on your behalf and make sure it all goes right. And then it's all, of course, invested while it's with us. And so that portfolio grows over time. You can even choose your own financial advisor. We're usually all working together on your behalf to continue to manage that investment portfolio. So you know and trust that that's being managed by some of your favorite folks. Here's what the form looks like. It's on our website, which is real easy to download. And I'll point to that in just a moment. So here's how to talk about charitable giving. If you're a professional advisor, I know some of you are. So identify the charities that you already support. Some people are already charitably inclined. Maybe they aren't giving to charity, but they volunteer, they serve on boards. Maybe they don't do any of that. Maybe just find out what their interests are. And we usually do those type of probing questions, and we have some tools to kind of navigate through all of that. Some of those resources include the step-by-step charitable giving guide. We really like this because it narrows down the focus of what people want to support. And by the end of filling out this little survey, they feel more secure on, okay, I understand what's important to me is now going to be reflected in what's in my trust. And why choose a community foundation? I mean, really, we are there when you're not, to be quite frank, and we have the local expertise. We have a national back office provider. I mentioned Greater Kansas City. So if you have an interest that is across the United States, maybe it's heart health, or maybe it's diabetes support or something like that, we can be that vehicle to give on your behalf nationwide as well. But our expertise really is local, and then we can pivot and shift according to what's happening in the community to fulfill what you wanted long after you're gone, to really leave that lasting legacy. So just the takeaway we want to give to you before we open it up for Q&A and show you some resources are, if you're a professional advisor, this is something where we can be in the background and feed you information so that you can have those conversations, or we can be right there at the table with you and your client, filling them in on what all of their great options are, or we can work directly with your client where you're doing more of the financial advisor or the trust piece, and then we're stepping in to help them craft that and then coming back to you and letting them know what options they've chose. If you're an individual, we understand that not one size fits all. So the options that I showed up there are branches to that. And we love learning what your goals are, what your needs are, what your desires are, and really finding something perfect for you. I'm just going to go quickly through our website. Here is where you can find some of the resources, longbeachcf.org. You click on the Give Later button at the top. Here you've got for individuals and professional advisors, specific pages and that are tailored for those two audiences. You've got calculators, you've got technical information if you so inclined, and here's where you find for professional advisors. We have all sorts of documents here and informational pieces that can really help you with that conversation. A little fast, so I'm going to slow down. I'm going to look at the chat for some questions, and I'm going to go ahead and see here, and we do have quite a few people joining us. So let's see. I see something here about valuable personal assets such as art, jewelry, etc., to be held in a trust. Jenny, do you want to take that one?
I do. I wrote in there my Schedule A. I keep going back to that schedule. Lists all tangible personal property, includes artwork, jewelry, and vehicles. And then my trust has the ability for you to do a memo of understanding for who gets what. The answer is yes. If you have valuable items inside your home, you have to connect it to the trust. Those items don't require anything more than just writing it down, and you get to say who gets what. It eliminates all the fighting. I had direct client stories. I had one come in 2 weeks ago. Mom died with 8 children, and they all left each other, but mom had lots of jewelry. So the kids came in with all of the jewelry and coins and $2 bills. And it took me about 5 hours to sort everything because they couldn't agree who was going to get what. And mom had a belt buckle that said the name Edward. And she had 2 grandsons named Edward. So they started fighting in my conference room over which Edward was going to get the belt buckle. So I had to say, look, at $500 an hour, I'm going to take all this stuff, go in the back room, and I'm going to create 8 even bags of items. And I'm going to put one $2 bill in each, one ring in each. And I filled up each bag, and I took that belt buckle named Edward, and I dropped it in a random bag. And I said, here you go. You have your Easter basket of mom's things, because mom didn't write down who was going to get Edward. So if you're going to have kids that are going to squabble, then you should write it down.
Great point. And we do see clients that itemize the smallest things, which seems kind of overbearing, and to have the conversation, but it actually really helps come that time. Highly encourage it. One of the questions that we get asked a lot here at the Community Foundation is, what about, other people involved? So sure, I'm going to tell the Community Foundation what to do, sell my home, put the money into a donor-advised fund or a scholarship fund, for example, and give it out on my behalf. But what if I want my nephew involved? What if I want my niece involved? What if I want my neighbor involved, my business partner, my surviving spouse, my, any and all those people? The answer is absolutely yes. So we take successor advisors. So when you pass, we'll have that on file, and we can engage that individual to act on your behalf. We just suggest that you have that conversation with them because then, so there's no surprises, and find out really if they want that position. If you don't have the conversation and you write them in and we connect with them and they don't want to have anything to do with, that's fine too. That's what our board and our staff are for. But there are situations where we find that. So one example is where we had a property on Catalina Island, and it's kind of a textbook case of a charitable remainder trust. The individual was able to live in the home until they passed, and have rights to live there. But in the meantime, the Community Foundation legally owned the home, but they had the rights to live there. When that individual passed, the assets, we sold the home and we put it partially to a charity and then partially into a donor advised fund who has the advisors or the people that are going to choose where that money goes by the decedent's friends. So and if the friends don't know where to give it, we work with them directly and advise on that. So lots of tips and tools there. Another question we get asked is, what about fees? And so I know that Jenny, if you call her up and you want to have a conversation with her, she can discuss that with you directly. A lot of times we find that it depends on, how complicated your estate is. If you have a basic home and you've got, a few family members and it's a simple thing, the cost is going to be minimal. But if you've got a lot more going on, it's going to be expanded. In terms of the community foundation, that is right around 1% is what we charge to administer all of that on your behalf, and 1% of whatever the assets are. So if you have $1 million estate and you want to give it all to charity, then we're going to charge that nominal fee 1% of 1 million in order to do all of our due diligence work, our investments, and grant making on your behalf, perhaps. And of those funds that I mentioned earlier, they have slightly different fees, but it's an average of about 1%. And the larger the dollar amount is, the smaller that fee goes down for you. So we're a charity. We try to keep our fees low in an effort to foster philanthropy and get money out into the community. So that's our business model and our structure. Okay, we are at 12:41 and we said we were going to 12:45. We have 4 minutes left. Jenny, is there anything else that we might have missed or anything you want to elaborate on, or what kind of questions do you get on a regular basis?
No, I think you did a great job. I do have another story to share why the foundation would be important. I picked up a trust yesterday that had charitable gift of $1 million to UCLA for medical school purposes. And the attorney who drafted the trust didn't write that down. They wrote down UCLA. So I had called the school and I said, does it go to medical school? And they go, no. You come to the campus and we use it however we want. I went, wow. Had this woman contacted Marcelle at the Long Beach Community Foundation, set it up, and in the trust said, I give $1 million to the Long Beach Community Foundation for the purpose of helping students at UCLA Medical School, Marcelle would use her power to make sure that money went to the right place. This money is going to the wrong place. And even if she's getting 1% at $10,000 of $1 million, the person who passed away would be blessed beyond belief to have it go to the right place. So it's important that if you're giving charitable gifts, if you don't know where they're going, that you pull in the experts to help you.
Well, that's a great story, Jenny, and really indicative of our value because, it's like an extra set of eyes to make sure that we're representing you properly. And we do see, you could write a charity or charities into your trust and not use the community foundation. But what you're missing is charities close over the course of years and decades, or they offer programs that are no more applicable to the community. And so you might have funded a after school program that's now not available. So now it's up to that charity to choose where those dollars go. If you have a good relationship with them and you trust them, then that's wonderful and you should do that. But if you want to have an entire sort of entity representing you there, it's really important to do that and to make sure that the money's being spent the way you intended. One word we didn't mention, and I'll wrap up here, that's really important is the word endowment, because we can give so much more after we go. And if a charity gets $1 million or $5 million from your estate, and maybe they know it's coming, they're going to spend it hopefully the way you intended, and that happens every day, and that's great. But we have seen a lot of cases where it's very enticing and very tempting for a charity to get $1 million and maybe just eat a little bit of it, maybe not save it and just spend the income, which is the definition of an endowment. But we really need this one thing, so let's take a little bit more and a little bit more and a little bit more. The next thing you know, they're coming to us asking for grants because we're grant makers, and we say, well, what happened to that endowment? Well, we needed it for this, that, and the other, and now we need more money. So if you wanted to sit with a trusted entity that will not unlock it because you told us not to, Or maybe there's stipulations where you do want us to unlock it. We have a few of those as well. So a lot of information here today. I do want to encourage you to reach out to us, reach out to Jenny, sit down with her, chat. That Schedule A sounds so valuable. And I'm sure she'll be wanting to share that with you. LinkedIn is a great way to connect with both Jenny and I. And we're on there, and Jenny's real responsive on there as well. And we do have a survey coming to you right after this and a copy of this presentation. So please go in there and take the survey and let us know what you think so we can make improvements as we go along. Wishing you a wonderful Friday, everybody. Have a great holiday, and we'll look forward to seeing you soon.